So we continue to analyse what is coming out of this tribunal. We're joined by legal analyst Mr. Elton Hart via video link. Mr. Hart, a good evening to you. Thank you so much for joining us. Appreciate your time. I think that what I do want to do is just get into your view of the trajectory of this tribunal and where it's gone so far, with the judges' defence now putting forward their own witnesses, and certainly points that stand out on what we've heard so far with the testimony of Ms. Nkqayi.
For me now, if I look at the trajectory, then I would look at now, it's here you have two mutually destructive type of testimonies that coming in. The ones from Mengo's side, and now the judges, the witnesses that's coming to testify. And this Nkqayi lady I think she was put under tremendous pressure during today's proceedings. But I mean, she stick to her guns to say, listen, yeah, this is what I observed. And I think it will come down to where they have to now make a credibility finding amongst the witnesses to say that who was testifying honest and frankly, and based on that, they will then come to a conclusion. And I could see that this Nkqayi girl, I don't want to say girl, I say that Nkqayi witness, let me be correct.
Yeah.
She's a big lady. She actually conceded certain things and she stick to her story.
Yeah, but what do you think the legal representation of the JP wants to focus on the events of one particular day and not perhaps even broaden the question that they're asking the witness with regards to the relationship between Mengo and JP as a secretary who would have been closely aware of what those interactions would be?
I think most probably they might still go to in that area with another witness to say that, because obviously one can also have to say that maybe the secretary of the JP has a certain type of bias in her, and maybe they might call another witness, we're not sure yet, that can actually say that if they could actually see that there was a type of a romantic type of relationship between Mengo and the JP at that specific point in time of the alleged incidences. But what was now clear from Ms. Nkqayi's testimonies is that she actually highlighted certain dates which was important in Ms. Mengo's complaint as to that certain inappropriate acts happened, and she could clearly give account with clear particularity as to what happened to her. So I think they might be playing it in that way and not saying that she must testify about everything, because then it might just be like a one witness who should lean a little bit to the JP than to Ms. Mengo.
Yeah. So this is the list of clients that we are of witnesses that we are expecting now to take the stand in the defence of the JP. Of course, Advocate Moses Kakane having mentioned that we would have two court secretaries, of obviously Nkqayi being the first one, the tribunal chairperson, retired judge president, of course, no, apologies, two court secretaries, and then at some point we'll have the JP himself taking the stand. But this was particularly interesting, that then there was a debate around whether or not Mengo's legal representative would be able to cross-examine the witnesses put forward by JP. And that debate getting quite difficult, in the sense that the rule, according to what we hear from the tribunal, is that cross-examination is not going to happen by the legal team of Mengo. How is that possible? Explain that to us, please.
One needs to understand that this is type of inquiry, but it's not on the level where you have like a court setup where you have two opponents. Because here she went to go and lay a complaint, and the JSC is actually investigating. It's an internal inquiry. So the normal adversarial nature that we know of court proceedings is not really here. Because I think the chairperson, from where they're sitting as the chairperson of the hearing, they would have certain powers to actually also probe the witnesses and the people that's sitting with them on the panel, to probe the witnesses pertaining to certain testimony. The reason why you would find that the JP's legal team, they're just leading the witness so that they aid the panel in actually listening, because it would be difficult for the panel to ask the questions of this witness and also making notes and stuff like that. So it's like more or less just a logistical thing that they do it actually to assist the panel, because the panel members can also go after Nkqayi and ask her questions where it seems that she's most probably not clear or maybe not direct with answers, or maybe sort of half hiding information, if one can put it that way. So this is the nature of this type of proceedings. It's like they would normally say in legal terms, sui generis. It's not like a normal court proceeding where you have examination in chief, cross-examination, and re-examination. It's a little bit different here.
Yeah, because I mean, it stood out to the retired Gauteng Judge President Bernard Nkqayi making that ruling that there would be no cross-examination of Nkqayi by the legal team of Mengo. Does this put Mengo, though, at a disadvantage?
No, I don't foresee that it puts her at a disadvantage, because she laid a complaint and then the commission or the panel is busy to investigate this complaint, and actually witnesses come and testify that Mengo made the reports to, that come and say that, but was this complaint, and they would investigate the complaint. Because that's how it normally goes. And then obviously the legal representative of the judge is there to make sure that his rights is not sort of half disregarded, in making sure that they ask the questions to say that this is the charge, because there's not really a charge that's leveled against Mengo. Mengo doesn't need to sort of have now, because there's like sort of half, I don't want to say an onus or a burden on the judge, but obviously there's a complaint and you need to give, and there's prima facie evidence that these incidents has happened, and now the judge needs to give sort of half a explanation as to under what circumstances these evidence or these incidents happen. So that's why you have this process where that cross-examination by the, I don't want to even say the defense, I would rather say the judge's witnesses is not on the table, and that's why the judge made that ruling to say that in this instance, cross-examination is not going to happen, because it's still a fact-finding mission. Because they're busy on a fact-finding mission to find out if these things actually happen, and from there they will make a recommendation if the JP should be now removed or not.
Yeah, I do want to get into the previous testimony that we did hear, though, before we saw Nkqayi taking the stand. Lisa Vettin's testimony, my goodness, getting quite a bit of reaction, right? And what you make of just some of the debate that took place there. Lisa Vettin, a gender violence expert, who has talked about how, the labor laws that govern a workplace, do so to ensure that there is never a blurring of lines between those in power and those, of course, who are not. But the line of questioning that she received was, did she have a full understanding of Xhosa cultural norms around courting? I thought that was a very, let's say, colorful line of questioning, that the cultural element could be an important part of this discussion.
No, it can and it should, because obviously one needs to always see things in context. Because if you say in South Africa and you use certain words or expressions in certain communities, it carries a certain connotation, good or bad, that it can carry a certain connotation. So one needs to understand also the context in which certain things happen. And I think it's important. And obviously, I looked at that, that it was a fierce back and forth between Advocate Sikhakhane and Ms. Lisa Vettin as to what was happening there and how you see it. And obviously, even where he was now saying that she's a little bit biased towards a certain section. So it was heated, but obviously one needs to know that Advocate Sikhakhane is appointed for a specific reason, to prove that there is not just one inference that can be drawn from certain things. There can be 2 or 3 or 4. And once he proves that there's not the only inference that can be drawn from the set of facts before you, then that is where the doubt lies. And that is the only thing that a lawyer needs to do, to say that, listen, if there's 1 or 2 or 3 other inferences that can be drawn, he's done his job, because then you can't out and out conclude that this is the only outcome if something is said or done in a specific way.
Yeah, just a last one, of course. After the testimony of Ms. Nkqayi, we are expecting one more court secretary, and then I think this is the moment that many South Africans will be watching for closely when we see the Judge President Mbenenge taking the stand himself and testifying. Any sort of expectations as to the kind of strategy that we'll see him take up when he takes the stand? Elton, are you there?
He needs to just, because remember, he does not have, yes, I can hear you. Can you hear me?
Yes, go ahead. I can hear you now. Go ahead. Yeah.
Yes. I say the judge does not need to prove that he has not committed these offenses. Obviously, if he says that there was like a consensual thing, then obviously you need to stick to that.
We're really struggling with your line, but we're going to have to leave it there, Elton. We'll catch up again as we certainly see the Judge President of the Eastern Cape, Selby Mbenenge, when he does take the stand. I think we can certainly bank that conversation for then. But Elton Hart there, legal analyst, unpacking with us there the tribunal there on Judge Mbenenge.